right, looks like we're live now, so we can go ahead and get started. I'd like to just thank everybody for attending and for joining us for this important conversation about the Second Amendment. I think first we'll hand it over to Chris Brown, Brady's president, to welcome everybody to the event. Chris is a veteran of the gun violence prevention movement and has extensive background in policy, law, and grassroots activism. At Brady, Chris has shaped the conversation on gun violence as a national healthcare crisis, launched the organization's groundbreaking safe storage campaign, End Family Fire, and formed Brady's youth initiative, Team Enough, after the Marjory Stoneman Douglas High School. So thanks, Chris, for kicking us off today.
Well, thank you so much. And I want to acknowledge our distinguished panelists. Thank you so much, each of you, for joining us. I'm really looking forward to this conversation. It's incredibly timely, and obviously our legal work is a critical component of what we do at Brady. We work across Congress, courts, and communities to address the epidemic of gun violence in this country. Given our cause and how long we have been active in this domain and how much we've accomplished, I think where I'd like to start is just recognition that our gun violence prevention movement has incredible momentum at this moment. Just last week, I was with many other incredible champions and activists across the country at the White House in the Rose Garden, listening to President Biden talk about the 6 executive actions that he's taking to really beef up our nation's law enforcement function when it comes to gun dealers, and that is the Bureau of Alcohol, Tobacco, and Firearms. Many of the executive actions that President Biden announced last week are really common sense measures. They're not radical changes, but they're making sure that there's some real teeth in the agency that's charged with ensuring that gun dealers across this country actually comply with the law. Of course, President Biden has also directed with new budget in the infrastructure bill, $10 billion, and put existing resources, another $10 billion, to provide funding, critical funding to community violence interrupters across this country. They're doing incredible work to really attack the problems of the disparate impact of gun violence in Black and Brown communities across this country. And while organizations have operated at the local level across this country for many, many years, they have been chronically underfunded. This represents the single largest investment in gun violence prevention in history from the federal government, and there's more to come. One of the things I'm also really excited about is the nomination of David Chipman to be the next director of ATF. David Chipman is a veteran law enforcement officer. He served over 20 years, a distinguished career at the ATF. The ATF, many of you probably remember, used to be actually under Treasury before 9/11. When ATF was under Treasury, it did not have a confirmed director. The position was not subject to confirmation. Post 9/11, ATF moved to justice, and that position became confirmed. Since the move to justice, post 9/11, there has been one confirmed director of the ATF. It's long past time that we have someone who really understands the agency, can fight for the dollars that are necessary to ensure that we have the strongest enforcement system that we can, the best protection that we can. So we're so excited about the momentum happening. I'm so excited to celebrate it. And I just want to note before we move into this really important discussion that we have a lot to celebrate, and we hope that despite all of the horrors and perils of coronavirus, one thing that we're able to do this year is a virtual gala. We are celebrating all of the incredible movement in our movement on April 29th at 7 p.m. You can find the link on our website. It's free to join. So please come and celebrate with us and a few other notable people like Stacey Abrams, Vice President Kamala Harris, Arnold Schwarzenegger, Hillary Clinton, the list goes on, and really make this about a celebration about what's next. Of course, I think the reason that this conversation is so important today, among others, is that all of this progress that we are making, right now through executive action, what I hope will be in Congress with HR 8 and 1446 passed the House and pending in the Senate, and a variety of state laws that have passed, including 8 in my own state of Virginia. What all of that progress means is our movement is stronger than ever, but it also means we are more vulnerable to nullification in the courts. So the topic of this panel could not be more important or more timely. And we have an incredible group assembled of experts to really help us understand what's at stake and how we should be thinking about these really important issues. So with that, I will turn it back over to you, Krista.
Thanks so much, Chris. And I'll have the opportunity to introduce our fantastic panel here. I'll start with Dr. Saul Cornell. Saul Cornell is the Paul and Diane Gunther Chair in American History at Fordham University and Adjunct Professor of Law at Fordham Law School. Previously, Dr. Cornell was Professor of History at The Ohio State University, where he also directed the Second Amendment Research Center at the John Glenn School of Public Policy. He has authored and co-authored numerous books, including A Well-Regulated Militia, The Founding Fathers, and the Origins of Gun Control in America, which won the David L. Langham Senior Prize for the Best Book in American Legal History in 2006. Dr. Cornell has authored the chapter on the right to bear arms in the Oxford Handbook of the U.S. Constitution, which is an influential reference work in American law. His most recent article on the Second Amendment and the history of gun regulation is History, Text, Tradition, and the Future of the Second Amendment Jurisprudence, Limits on Armed Travel in Anglo-American Law. Next, we have Dr. Marianne Franks. She's a professor of law and Dean's Distinguished Scholar at the University of Miami School of Law, where she teaches First Amendment law, Second Amendment law, criminal law and procedure, and law and technology. She also serves as the president and legislative and tech policy director of the Cyber Civil Rights Initiative. She's the author of the 2019 book, The Cult of the Constitution, Our Deadly Devotion to Guns and Free Speech. Dr. Franks earned her doctorate and master's degree in modern languages and literature from Oxford University, where she studied as a Rhodes Scholar, and her JD from Harvard University. Next, we have John Lowy. John Lowy is Chief Counsel and Vice President of Brady Legal. John has spent more than 20 years representing victims of gun violence in lawsuits to reform dangerous gun industry practices and assisted governments and public officials in defense of reasonable gun laws. And named as one of the nation's 500 leading lawyers, John has litigated in 40 states to reduce gun violence, including winning several landmark trials and appellate rulings, settlements, and verdicts. He's a graduate of Howard College and the University of Virginia Law School. So we have Professor Darrell Miller. Professor Miller writes and teaches in the areas of civil rights, constitutional law, civil procedure, state and local government law, and legal history. His scholarship on the Second Amendment has been published in leading law reviews such as the Yale Law Journal, the University of Chicago Law Review, and the Columbia Law Review. He has been cited by the Supreme Court of the United States and in congressional testimony and legal briefs. With Joseph Blocher, he's authored The Positive Second Amendment, Rights, Regulation, and the Future of Heller, and is co-faculty director of the Duke Center for Firearms. Miller graduated cum laude from Harvard Law School and attended Oxford University as a Marshall Scholar. And last but not to be confused with least is Hannah Shearer. Hannah is the director of litigation director at Giffords Law Center to Prevent Gun Violence. As the leader of Gifford Law Center's constitutional litigation program, Hannah works to develop lawsuits advocating for gun violence survivors and litigates challenges to dangerous gun policies and regulatory inaction, and serves as the defense counsel in actions challenging local gun laws and the Second Amendment. Hannah also coordinates the organization's efforts to track gun safety laws in the courts and analyze the impact of federal judicial nominees. Hannah regularly provides information and commentary on the Second Amendment, the courts, and state firearms law to media outlets, policy advocates, and the academic community, and is the author of Giffords Law Center's post-Heller litigation summary. Before joining Giffords, Hannah worked as a litigation associate at Munger, Tolles & Olson in San Francisco, and as a law clerk to Judge Paul J. Watford at the U.S. Court of Appeals for the Ninth Circuit. She received her undergraduate degree from Yale University and her JD from Stanford Law School. So welcome to all of our panelists. Thank you so much. Certainly very excited for this discussion. So I hope we have a fluid conversation. While I may direct certain questions to particular panelists, we encourage all of you to jump in if you want to contribute something. So this first set of questions that we'll move to, though, will mostly frame around trying to understand the scope of the Second Amendment. To open it up, I'll pose this to everybody. I think maybe I'll put John on the spot to answer first. Legal scholars have commented that the Second Amendment post-Heller is where the First Amendment was in the 1930s and 40s. The current majority of the Supreme Court favors bright line rules over the types of balancing tests that we see a lot of under First Amendment doctrine, which means that Second Amendment doctrine could develop quite differently. So I just want to open that for comment about how that implicates potential gun laws, or how you view that when you think about how the court might handle Second Amendment cases when they come up.
Thanks, Krista. I'd like to hear certainly the other panelists on this. I mean, it's really, in my mind, very hard to analogize the Second Amendment to the First Amendment or any other right, because in my view, the court really took a wrong turn with the Heller decision, and the proper, in my view, historical interpretation of the Second Amendment is basically what was construed before 2008 through the prior 200 years of American history, where the court held, as the framers intended, that the right was intended to protect participation in state militias, state armies. Then since the 5-4 decision in Heller, we're now in this area where the court is purporting to look to history, and in some cases what they call text history and tradition, when the history actually leads to a very different Second Amendment that would have no impact on the constitutionality of gun laws. So to me, it's a unique situation with a sort of ahistorical interpretation that purports to be historical. But I Professor Miller, Saul, Professor Franks, Hannah, I'm sure you all may have different views on this.
Can I just weigh in really quickly? So, what John says is sort of based on a set of assumptions about how the Heller case came down that not everybody might be familiar with. So the Heller decision itself relies on a mode of interpretation called originalism. Now, the kind of originalism that has now really gained ascendancy is not your father's originalism, where you try to figure out what James Madison wanted or what some other founding father, Thomas Jefferson, wanted. It is essentially a linguistic exercise, a falsifiable linguistic exercise. That is, you try to figure out what did the words of the Constitution mean to the enacting generation in 1791? What was the way that they most likely used and understood the terms that they used? And there's really been some very damaging new scholarship using very large databases of words contemporaneously to 1791 that cast some serious doubt on whether Heller was rightly decided as an initial matter. Now, having said that, I am on the record, as is my co-author Joseph Blocher, of saying that stare decisis certainly supports Heller, that there's no under conventional application of stare decisis, no conventional understanding that would warrant it being overturned. But I think the premise that the terms, as Justice Scalia writes about how the terms keep and bear arms were actually used and understood in 1791, are now under some severe strain using big data sets of 1791 information and just finding out how did, in fact, people in 1791 speak.
Great, thanks for that. Professor Cornell or Franks, would you like to add anything?
So the one point I think that's worth making, which I think brings together both Daryl's point and John's point is that at its current moment in American legal history, Heller has given us a kind of interesting problem. And interestingly, it's a problem that I think some of the originalists who've been appointed to the court recently are somewhat aware of, although they haven't fleshed it out fully. And that is what happens when the methodology that Heller recommends, which has an important role for history. I mean, there's some disagreement whether history is the only relevant or one of several relevant, but everyone agrees that history is part of the framework. What happens when the methodology that Heller recommends, or at least one strain of that methodology, produces new evidence that problematizes or calls into question some of the historical conclusions in Heller itself? So that is a really fascinating problem. And I can't really think of another case in American constitutional history with which was so self-consciously methodological, but where the methodology might undermine the holding of the case. And that's, a fascinating place to be, but not a place that I would want to be a judge having to sort out all of those details.
Yeah, great. I think this would be a great time to bring in Hannah. I'd love to hear, based on your litigation experience when applying Heller, what does that mean? The difficulty in applying Heller. What does that mean for actual gun laws or gun violence prevention policies?
Well, I think it maybe this is just a preliminary point. Heller did usher in a flood of litigation over gun laws, and I think that was going to happen regardless of how specific Heller was about the methodology to be applied. But one thing that gun rights groups, gun lobby groups seeking to challenge gun laws could capitalize on is the fact that Heller left a lot of questions open. And so just to name a couple of them, the decision was really not clear how lower courts should review history when they're looking at a different question than Heller was looking at. Didn't really offer advice about what to do if the historical record was unclear or if there was an absence of evidence about how laws were enforced. And then Heller also intentionally, the majority opinion, didn't specify what type of framework should be used to evaluate Second Amendment claims, alluded to the traditional tiers of scrutiny that are used in constitutional cases, but said that in the case of the District of Columbia, a handgun ban at issue in Heller, the court didn't need to select a level of scrutiny. So that's enabled some people to argue that Heller was rejecting constitutional scrutiny in favor of something else, and really just given litigants and judges who are sympathetic to them a lot of room to deviate from Heller, which was really quite a limited ruling because it confined itself to the facts of the law being challenged, and also specified that a number of common and reasonable gun safety measures are constitutional. So I think that litigants and courts interpreting Heller have run into the problem that Heller is limited and really left a lot of terrain open for interpretation.
Great. And Professor Franks, as we offer the mic over to you, I would like to just build on this discussion and ask you a more pointed question. Based on your book, The Cult of the Constitution, you push back against the Second Amendment as a super right, which is kind of how it necessarily is read if you apply bright line rules. So I would like just or have you discuss what you meant by or what you meant when you pushed back against that and said the Second Amendment wasn't a super right, and that the Equal Protection Clause and other rights have are necessary to consider when you look at how the Second Amendment should be applied to gun laws.
Yeah, and I guess I'd harken back to something that John said at the outset, which is there's a lot of reasons to look at the First Amendment and Second Amendment jurisprudence and say, look, they really shouldn't have any kind of analogy between them. And I think that's right for lots of reasons. As Greg McGarrian and others have talked about the actual interaction between the two, that if you're reading the First Amendment broadly as freedom of expression, that in some ways runs completely counter to at least the version of the Second Amendment, which is the right to bear arms in public or to terrorize other people. It can actually chill the ability for people to engage in free speech. And it also in some ways is a kind of resignation, right? If you're using force, it's because your words haven't worked. You are essentially saying from the outset, I don't want to engage in freedom of speech. I want to move directly to action and to intimidation. So there's something to be said about that, really, that's a bad fit as between those two. But I would say in a different way, in a negative sense, there's actually a lot to be gained from looking at the two in comparison, because I think the dangerous tendencies in the jurisprudence are there for both. That is, I actually think that a lot of Second Amendment extremism borrows from First Amendment extremism. That notion of a super right, the notion of a fetishistic attachment to one right without any consideration of others, read in isolation, read with extremely idiosyncratic viewpoints, and in my view, read completely tribalistically. That is to say, really in order to generate or perpetuate, I would say, the hierarchy that already exists in terms of who gets to exercise their constitutional rights. The Second Amendment jurisprudence is following along that, right? Let's talk about nothing else in the Constitution except for the Second Amendment. Let's have this highly contested interpretation of it that just so happens to benefit the most privileged people in society and has really negative impacts on everyone else. And let's say that anyone who disagrees with us is not just taking up a different position, but is in fact not a patriot, hates America, hates the Constitution. It's that same kind of extremism and what I call fundamentalism. And it really does resemble religious fundamentalism in a lot of ways. And so the concern that I have about both of the amendments is that people get intuitive, emotional, symbolic attachments to those rights, and they tend to emulate religious extremism in their attachment to those. And it becomes a tribe, it becomes a death cult. I don't just, when I think about where the court's going to go next on gun issues, I'm not even as worried about some of the actual gun cases they've either taken up or declined to take, as I am concerned about some of the recent cases that they've taken when it comes to COVID restrictions, partly because I think you're seeing what the court is saying about how they don't think, or they think that certain rights, let's say in the context of more recent cases, religious freedom, right? The ability to have people at your house or to hold these services is more important than precautions that might keep people alive. That's concerning for the Second Amendment context for lots of reasons. It's that same fetishistic idea that we're going to take this one right out of context, treat it as though it were a silo, as if we didn't have a constitutional ecosystem, and say this right is worth more than anything else, including people's actual lives. That's what really concerns me.
Thanks so much for that. And John, in many of Brady's amicus briefs, we argue that there's a countervailing right to live or right not to be shot, as you and Kelly Sampson have written in an article by that name. Can you explain what you mean by that and what that means for Second Amendment jurisprudence?
Sure, and there's a couple of major points that we make, Kelly and I, in our article, and one of them is similar to what Professor Franks was discussing, maybe a little bit different, but that is that every right, when construed by the Supreme Court, is circumscribed in some way by the police power authority of the state to protect public safety. And we frame that in the article as really recognizing a right to live, not to be confused with the anti-choice so-called right to life, something very different. And even though the Supreme Court does not use that term, that does come, of course, from the Declaration of Independence, and it's really what the police power authority of the state to protect public safety is all about, protecting people's right to live. And that authority is nowhere more important than when dealing with gun violence, with a right that actually has the potential to the exercise of a right that has potential to kill people. So that's one point. The other one, and our article is called "The Right Not to Be Shot" for a reason, and that is that when we talk about the right to keep and bear arms, of course, that's the language in the Second Amendment, it sounds a little more innocuous than it actually is, because of course, when people are claiming a right, for example, to bear arms, to carry arms in public, they do not mean that they want to carry arms as a fashion accessory to show other people. They want to carry arms because they want the right to be able to shoot people if they personally deem it necessary to protect themselves or others. So the right is not really a right to keep and bear arms. It is a right either implicitly or explicitly to shoot. And countervailing that is the public's right not to be shot, which in my view is a much more fundamental and important right than any right to keep and bear or to shoot.
Great, thanks. And Professor Miller, you had a point to add after that.
Yeah, if I could just pull together a couple of strands, because Marianne's pointed out quite rightly that the Second Amendment operates in a constitutional ecosystem. The right to keep and bear arms isn't the only right in the Constitution. It's not the only right that we have. And I think this is allied with what John was saying, which is the court at some point is really going to have to start addressing in a very serious manner what happens when you have sort of conflicting rights. The prime example, I think we've seen that in the past 6 months or so, is the right of political participation. So to the extent that we understand voting, political participation, the ability to peacefully assemble and make known your political preferences in a safe, peaceable way. These kinds of rights are coming into conflict with others who extol the right to keep and bear arms above all others. And at some point, the Supreme Court is just going to have to address, is it okay that it's possible that we would have a scenario where a person would have to navigate a gauntlet of armed individuals to go vote? We're going to have to deal with the fact that people might not actually want to express themselves in public places if they are concerned that there is going to be an armed assembly there, which distorts the way we understand public participation. And at some point, the court is just going to have to address this. There's just no way in the next 10 to 20 years that the court can avoid these clashes of values.
I agree with Daryl, and just wanted to quickly say, I think this is one of the reasons why it's so concerning that the court seems like it's going to shift to a bright line rule or something like the text, history, and tradition test, because that doesn't factor in other rights. And right now, the lower courts have hit on an approach. It's a two-step approach where there's constitutional scrutiny applied at the second step, like intermediate scrutiny or strict scrutiny, and that's where courts can consider, well, this regulation of guns is needed because otherwise people's First Amendment rights are going to be chilled, their political participation is chilled. And if you get rid of that step, there's no point in the methodological framework that the court is going to be thinking about other rights. And the other thing I just wanted to add is that I think John's remarks about how the right to keep and bear arms has been read as a right to use guns, or that's how proponents of an absolutist view of the Second Amendment want it to be interpreted. I think another thing the court has to reckon with, if it is close to accepting that, is the fact that Heller says this is a right that's connected to self-defense. And so self-defense properly has limits that governments can impose. And if Second Amendment jurisprudence doesn't think about what self-defense is and when it's appropriate to regulate the defensive use of guns, I think it's going to turn into a dangerously unbounded right that really is infringing others' right to live, infringing others' First Amendment rights, and any number of other rights.
Great. And Professor Cornell, I'd love for you to chime in, but I kind of want to add something on top of that, because I think what everybody's saying brings to mind, whose rights, to keep and bear arms are going to prevail over the public good, whose speech rights are going to prevail over the public good, and how that necessarily implicates, the racial history in the United States. So Dr. Cornell, you've written about the interplay between race, slavery, and the development of gun laws throughout US history. So I'd love to just hear your thoughts on how you think the way that we balance whose got the authority to assert their right over the will of others in that context.
Well, there's no question that race is deeply implicated in the history of gun regulation, the Second Amendment. There's a lot of jockeying for moral authority in the modern debate by very selectively invoking part of that history. So you often see gun rights activists argue that gun regulation is inherently racist, that it was only used to disarm African Americans. And of course, in certain historical contexts, there's no question that gun laws were used to disarm African Americans and to enforce racial hierarchies. But of course, there are other historical moments where that's not true, where gun laws are racially neutral and in fact are essential to protecting the interests of free persons in the Reconstruction South, in the later part of Reconstruction. So I think one of the things that we see often in this debate is a kind of selective move to history. People move to history when it's the history that suits them and that furthers their ideological agenda, but they don't engage with a more genuinely and nuanced approach to history. And that gets us to the sort of issue of law office history, which actually comes up in the Young decision, which was recently decided. It was quite remarkable to see the Young majority point out the dangers of putting so much emphasis on history, what a burden it places on courts to adjudicate very, very difficult historical questions with lots of evidence that's sometimes contradictory, with gaps in the historical record. So ironically, as a historian working on this debate, I sort of wish it was a little less historical sometimes, because it is, I sometimes joke that it's such a fascinating historical topic. I kind of wish it didn't have such contemporary interest and such strong emotions, because then we could really deal with the layers of historical complexity more calmly, instead of just playing this, historical, something equivalent to a historical treasure hunt, where each side sort of tries to dig up their own little nugget of Second Amendment history that they can then plug into their brief and say, so history supports us in this particular litigation. So history is very complicated, and so far we've done a lot of the talk about rights, and of course what has been the most interesting part of the scholarship since Heller is the incredible almost archaeological effort to dig out the history of regulation. And I think that when Heller went big into history, they didn't really anticipate how much history there would be and how much support there would be for regulation.
John, did you want to add a point?
I mean, I think Saul was being maybe too gentle to the judges who've construed Second Amendment cases. I mean, it's remarkable that the politics of judges always perfectly aligns with their historical conclusions, and that's not coincidental. I mean, I don't think anyone is of the view that if there were records making clear what James Madison meant, or to Professor Miller's point, what the public understanding of the Second Amendment was, that proved that the Second Amendment was limited to militia, that Justice Scalia would have come out the other way. I don't think anybody thinks that, and that's so there is this. What Saul calls the law office history, that history is largely viewed like evidence is used by a litigator, which is you frame the evidence to support your case. It's an adversarial system where you're not looking for truth, you're looking to win your case. And unfortunately, we've seen judges do that quite a bit with the Second Amendment.
I'd like to add I'd like to add a little bit, and I think, John is, so in fairness to Judge Bybee, who just wrote this opinion in Young versus Hawaii, I think it's fair to say the expectation based on his being a Bush appointee would that he'd zig in one way, but he looked at the history and went in the other direction in terms of looking at it comprehensively. So in fairness, it's, the ideology doesn't always predict the way that the case is going to come out or how the history is going to be assessed. I think the bigger issue that when we talk about this sort of text, history, and tradition approach really is the issue about the levels of generality and what do you do when you just don't have anything, or where the level of generality just doesn't help you any. So I think, the problem that I see often in text, history, and tradition approaches is that you get really broad understandings of what kinds of things come within the protection bucket, but not in the regulation bucket. So, many of people on this call have seen gun rights advocates sort of say, look, in the 18th century, there was a patent for a multi-shot, weapon called a puckle gun, and therefore, semi-automatic rifles with extended magazines are protected. And then when you look at the regulation side, you have to look for it. If you're on the gun rights advocate side, you're looking for, you're saying, well, the government has to have a precise analog to the kind of regulation that exists. So since there were no regulations on, guns in the hands of 18 to 21-year-olds, then it must be unconstitutional. And I think you have to think about the levels of generality on both sides of this equation, not only on the right side, but also on the regulation side. And then you really have to come up at some point with the fact that the analogies are not going to work anymore. Prohibitions on pistols in the cabins of jet airplanes have only been around since the 1960s. And it seems strange if you end up engaging in some kind of historical analog argument that a commercial airplane is kind of like a coach or a ship or something like that. It just, it has the whiff of the scholastic about it that I don't think puts the judiciary in a very favorable light vis-a-vis their decisions.
Great, thanks. And Hannah, I'd love to bring you in now to kind of bring some of this down to what that actually will look like for, actual Second Amendment challenges that are working their way through the courts right now. So we've heard the histories in dispute. Essentially, lawyers are able to find things to support their arguments, and judges don't have a clear mandate on how to apply that. The appropriate level of scrutiny isn't defined and things like that. So when the Supreme Court takes a case, like what's on the menu in terms of gun violence prevention policies of things that might be upheld or struck down given all of these ambiguities in the law at this point?
Thanks for the question. And at the outset, I'll just say I don't think it's possible to oversell the stakes of what could happen at the Supreme Court, especially because I think there's a lot to focus on right now with the issue of gun safety and gun violence prevention. And people are rightly focusing on executive action and possible congressional action on gun violence prevention. But we've also got to keep an eye on the judicial branch because we've now seen 4 of the justices on the Supreme Court say that they want to take a Second Amendment case and would likely want to strike down more gun safety laws. And with the addition of Justice Barrett, she's likely aligned with them ideologically and would supply a 5th vote for some of those outcomes. So just to highlight some of the specifics quickly, there's 2 major issues the court could take up really soon, like as soon as on Monday, they are issuing orders and could vote to hear one of the major cases I'll talk about. So one issue is guns in public, the issue left open by Heller, whether states can adopt strong licensing standards that restrict who is allowed to carry loaded guns in public. Or if instead states have to kind of treat that on par with keeping guns in the home. And, this could conceivably lead to a decision that's like Heller for outside the home. And then the other issue that the court could take is, it's a pretty different subject. It's the issue of who can be prohibited from gun ownership after a criminal conviction, and for how long, and whether you have to look at these on a case-by-case basis. So there's several cases challenging the federal law that prohibits gun possession after conviction of a felony, and then also some serious misdemeanors. And at least one justice, Justice Barrett, has said in a prior dissenting opinion as a circuit court judge that she would find this law unconstitutional unless there's an individualized showing that the offense committed makes the person dangerous. So, and that's a showing that she wouldn't require in the voting rights context. So it's kind of specific to her interpretation of the Second Amendment. So those are the two issues before the court, and I think others can probably talk more about the stakes, but yeah, it's going to happen soon, I think, sooner or later, and it could happen as soon as Monday.
John, I think if you want to jump in, I'm curious to hear, we've got Hannah who's highlighted some of the real policies that might impact people's lived experience in the country alongside all of these heady challenges with the constitutional doctrine. With all of that at stake, what are we to make of the meaning of the militia clause now? And what does that mean for our ability to pass gun violence prevention policies?
So first off, I agree completely with what Daryl said, that I painted the judiciary with too broad a brush, and he was right about Judge Bybee, and there are some other judges who seem to apply history in a principled way, but not enough, by my view. And I'm sure we'll go back to history, but before we leave the discussion of history for now, it's worth stepping back for a moment while and realize how absurd it is that to some degree, when we're deciding whether Americans should be allowed to enact laws that prohibit military-style assault weapons, for example, to prevent mass shootings, that decision may turn on judges analyzing what laws were like in 18th, maybe 19th century America, with a very completely different culture, rural, the technology of firearms having absolutely nothing to do with the firearms that we have today, and certainly not assault weapons. And I think most Americans would be rather stunned that actually is where the fate of their gun safety laws can turn on. Which is one of the central problems of this historical approach that's being used. But I would like to hear from the others on the as far as the relevance of the militia clause today, because I think I will be far too glib about it. There was a cartoon that came out after Heller, which I still have on the wall of my office at Brady, which had the Heller majority justices painting over the first half of the Second Amendment, well-regulated militia being necessary for the security of a free state, and then putting the paint away and saying, and now let's go back to bashing judicial activism. And it does, at its broadest level, certainly Heller can be read as sort of doing away with the first half of the Second Amendment. I don't think that's actually true, but it is certainly hard to make of what's the relevance of that phrase under Heller. But I do think that in all these subsequent cases, it will be revisited. The history will be revisited for all the reasons that others have said, particularly because there's new history, which makes it even more clear what the meaning of the Second Amendment was. So maybe there'll be, maybe the meaning of that first half will be elevated. for 200 years, the first half Second Amendment dictated what the Second Amendment meant. And now, at least for the past 10 or so, we've gone the other extreme where it's been of very little relevance.
Great. Professor Mill, you've recently written about a potential application of the militia clause to cities. I'm open it up for just any general reactions you have about the militia clause, or if you want to talk more directly about the article you've written.
Sure, yes. It's not about the militia clause per se, but I think it's a response to John's point, which is what Heller did was it's essentially destroyed the one political institution, the militia, that was used to like manage a bunch of Second Amendment questions. So before Heller, if you had a question about, is this an arm that's protected? Is this kind of behavior protected? Is this a person that's protected? You ran that all through the militia clause as a political institution to answer those questions. Most importantly, I think, most importantly, having to do with this issue about public arms, the militia clause is what organized public display and use of weapons under the Second Amendment. So this piece that I've written with my co-author Dave Fagundis called "The City's Second Amendment" says, well, since the militia as the political organization has been essentially removed from organizing the public display and usage of weapons, what other kinds of political institutions exist, if any? And I think we're really getting a kind of road test of this in recent years, which with people just sort of saying, hey, I've got a unilateral right to assemble with my pals as a sort of self-designated militia. And what the city's Second Amendment piece says is, well, maybe the city as a group, that is, as a political organization, as a bunch of people getting together and saying, how are we going to defend ourselves, has its own Second Amendment interests in play. How would that cash out? Well, it might cash out in ways having to do with how cities or localities make their own decisions about gun rights and gun policy, even if the state has a different gun rights or gun policy. It gives meaning to things like when a group of people say, hey, we're going to patrol the streets of Atlanta as a militia, they are not doing something just for themselves. They are acting on behalf of the public, and therefore the public has an interest in regulating that kind of behavior. And so this piece is trying to get our arms around a post-Heller, basically taking Heller at its word. It's not going to be overturned. Is there any kind of political institution that can address the public aspects of arms bearing in America after Heller?
Great, thanks. Does anybody have anything they want to jump in and add to that related to the militia clause? If not, I think another thing I'm thinking about is, we know that there are disparities in how gun violence impacts certain communities. So while suicide rates might be higher in rural communities, we've got homicide rates that are higher due to gun violence in urban communities. And when a state enacts a preemption law that prevents localities from addressing the types of violence that are impacting their community, there's definitely an issue of race and the exercise of political power. So I just want to hear a little bit about how you view preemption laws, the Second Amendment, and the ability to respond to kind of what's a dynamic and very multifaceted problem of gun violence around the country.
Happy to say a few things about that kind of tie back to one of the points that Hannah made about how one of the extraordinary thing about Heller is that we're talking now about the realm of individual self-defense. And the extraordinary thing about the gun lobby's propaganda is that we have become so used to associating self-defense with guns that it almost goes without saying. And that's, I think a real part of, whatever we want to call this popular constitutionalism or pushback or legislative innovation here has got to be to pull those apart entirely. for a lot of reasons, not least because if we look at things from a self-defense perspective, all the empirical research points in the same direction. Guns aren't good for this. If that's what you're trying to achieve, this is the wrong tool. So if we're going to shift the focus away from militias to individual rights of defense, then this doesn't make any sense at all. That's one piece of it. The other piece of it is self-defense is got all these trappings and nuances associated with it that have to do with necessity and proportionality. And even if we thought that guns were good for self-defense, there's still all these questions about what that means. You can't simply be preemptive in your approach to self-defense, because if you are, you're basically doing what John was saying before, which is your right to shoot just completely overrides anyone else's right not to be shot. That is, among many things, just a statement of anarchy. It's saying, I don't want to participate in the social contract. I want to be judge, jury, and executioner for anything that crosses my path. And that is really saying that, I mean, this is the great irony of this being something that people promote as constitutional fidelity, or is that this is somehow in some sense an honoring of the Constitution, when in fact it's a repudiation of the social contract that underpins the entire idea of a constitution. So trying to separate those out. And then we can bring in all these questions that I think you're already gesturing at, which is, if we're really talking about self-defense, now we do have some interesting stories about who it is that needs to defend themselves and what do they need to defend themselves against? Because in many cases, the answer is going to be men with guns is what we need to defend ourselves from. So how can that be the solution? And then to start looking not just at the racial impact of that, because of course that's a huge part of this, but looking at the gender impact of this. On the one hand, the gun lobby is very fond of trying to pitch guns as a way for women to protect themselves. But notably, when they articulate that campaign, it's always, you're going to be in a dark alley, someone's going to jump out, and you are going to whip out your gun and shoot them. When, of course, we know that domestic violence, sexual assault, all of those types of crimes and abuses that women are much more likely to face are going to not come in a dark alley, but probably at home or on a date or at college. And the idea that a gun is going to be useful there, or that the state will support that woman's right to use that gun. That, you know, if we pay attention to the practice here, we would see that that's obviously going to be absurd. Not only is that not practical for women to use, but it's also the case that when women do in fact fight back using guns, kill their abusers rather than be killed themselves, the law is very punitive. So we can encapsulate a lot of this conversation in the Stand Your Ground movement that has really taken off, due in part to the NRA's very effective push for these laws. And we can look at the completely unsurprising statistics about how this plays out racially, that you're far more likely to be able to get off with a stand your ground defense if you have shot a Black person, like exponentially more so. And it increases homicides in the states where these laws have been passed. So we have this issue. Sorry, there is a cat that has wandered onto my balcony and someone is retrieving the cat. I apologize for the expressions that I'm making. So if you look at those statistics and you also look at the fact that Marion Hammer and others at the top of the NRA, when they were promoting Stand Your Ground, which effectively was billed as a shoot more people in more places type of thing, when you're thinking about that, Marion Hammer and others made clear that this was not meant to be a solution available to women inside their own homes. It was not meant to be something that women in domestic violence situations were supposed to take advantage of. So it was one of these close moments, the Marissa Alexander case or other domestic violence cases, or the Philando Castile case, where the gun lobby shows what it really means when it says, when we want more gun rights, when we say self-defense, we literally mean for white men in certain contexts when their authority is being challenged, and really not for anyone else. Because there would be a plausible story to tell in terms of why do Black people, Black communities need self-defense? Why, for instance, do women need self-defense? Because the state has abandoned them, because there is no protection against the abuses that they might suffer. So I think that is, you know, it does highlight, right, who it is that we're actually talking about, and might also give us some sense of what will happen if we are going to get movement on this, how much of it is going to be about trying to show that the people that you weren't expecting to use the guns in self-defense actually do use them, right? We all know about the Black Panthers showing up with weapons and suddenly we get gun control in this country. What would it mean, right, if we were actually going to bring equal protection claims that said you're not protecting people's Second Amendment rights in the same way? And when we say, you call it militia, I'm going to call it a gang, and I'm going to say I have a Second Amendment right to be in a gang. will that actually change, or at least make some people in the court nervous about what it means to fully apply Second Amendment rights across the board? But the reassurance that so many groups can have about this is that the theory is never going to be the practice. We know that if you're going to tell a woman, take a gun and defend yourself, she's not going to either be able to defend herself or she's going to end up in jail. And we know that if a Black man actually picks up a gun and tries to defend himself in his own home or outside the home, we know that he's going to get shot dead, or even looks like he might have a gun. So if you have that massive deterrent effect that tells people preemptively, we don't mean you being able to use a gun. That's why I think there's such a comfort level on the part of the majority of the Supreme Court to say, when we support these really ridiculous, extremist, absolutist interpretations of violence and self-defense here, we can be assured that we mean these people and not these other people. And I think never was that clearer than when Donald Trump said at one point, he said in a speech, he said, we're going to see them with the guns and we're going to take their guns and not even ask questions about it. And you would have thought that the NRA was going to freak out. You would have thought that there would be some pushback on this. There wasn't. And then he goes back and he clarifies a day or two later. He says, I was talking about Chicago. And it's as close to sort of an explicit statement of what he meant. I meant Black people, right? I meant that we're going to not keep in, when we say pro-gun, we don't mean pro-gun. We mean pro you guys with guns and everybody else is the bad guy that you need the guns to be protected from. So is there going to be a strategic or other way to try to make that really apparent and somehow dislodge this complete myth that this is about Second Amendment self-defense rights for everyone, because we all know that it isn't? Is there any way to dislodge that and actually force us to confront that history and that legacy?
Great, thanks so much. And I'd love for others to weigh in. I think what I'd like to mention is, so Professor Miller, you and Professor Blocher wrote in your book about how there's a couple different theories or lenses through which to read the Second Amendment. And Professor Franks mentioned the self-defense lens, which we hear a lot of and was recognized in Heller, but there's also this anti-tyranny motive that might be implicit, and that is woven into how we dissect what's the difference between self-defense versus something that the government has authority to step in and stop. And I'd love to just hear what your thoughts are and what Professor Franks shared and what the interplay is between the Second Amendment, the logical conclusions of an anti-tyranny reading of the Second Amendment, which Josh Horowitz calls, the indirect insurrectionist theory, and how that relates to what we've been seeing recently, especially on January 6th at the U.S. Capitol.
Well, I think what Mary Ann says sort of ties in directly to this notion. So the first is that Heller as an opinion is kind of toys with this anti-tyranny rationale. There's lots of gestures in the opinion about how the people trained in arms are able to defend themselves against tyranny, and that's why you have personal arms. But as David Williams at Indiana said shortly after this case came down and Heller, the court's not really serious about like a full-throated embrace of the anti-tyranny rationale, because they know where that leads, and so it really becomes more about individual self-defense. I think what Mary Ann has said is really potent, because if we were to really seriously take the anti-tyranny justification, it would mean things like it would have been perfectly acceptable when George Floyd was being murdered for somebody standing around there, a Black person, to pull out the gun and shoot the cop. We don't have a culture, we don't have a legal structure that allows people to act as judge, jury, and executioner for police misconduct and police violence. And so that gives lie to what I wrote once in a piece about the sort of retail rebellion aspect of this. But even at the higher level, talking about January 6th, I think the cards were laid on the table when Senator Johnson said, oh, well, if this had been Black Lives Matter coming into the Senate building, then I might have been worried. But the fact that it was predominantly Trump supporters that were white, that were, actually assaulting the Capitol, I knew that they were fine. I can't think of a more genuine expression of the idea that a white man's government can only be overturned by white men than the statement that the senator made, right? So it's the fact that this anti-tyranny rationale is not only partisan, it's racialized. And I think that if we're really serious about thinking about it, we have to just accept the fact that it is acting at the bounds of law. There is not a legal mechanism to actually understand a right to rebellion. You can't have litigation that says, all right, how many shoulder-fired missiles need to be in private hands to actually, effectively deter the national army. And the fact that it's unadministrable in that way means that at the best, it's a set of political arguments, not legal ones.
Great. And so I think we see political arguments actually have, an impact on popular understanding of the Second Amendment. So Professor Franks, if you wanted to respond to Professor Miller at all, I'd love to hear what your reaction is to that, knowing that there is a strong contingency of, predominantly white men that have that understanding of the Second Amendment and believe that, what about shall not be infringed, do you not understand, and that it would include a right to rebel, and what you think that means for the Second Amendment going forward.
I mean, I worry about what it means for us as a country going forward, but as Darrell is saying, it has become very overt. What might have been more quiet before, is being said directly out loud now, right? That whether you want to trace this to Charlottesville, where you've got the groups descending there saying you're not going to replace us, to this revitalization of this idea that this replacement idea that there are people who are enacting what some number of people would say is the natural progression of the Constitution, that we might shamefacedly acknowledge the fact that when the Constitution was written, it is obviously written by and for wealthy white men, but we're aspirational about this, and that we come to this point of progress. You've got the Reconstruction Amendments, you've got the 19th Amendment, and you've got this idea that, okay, we never lived up to our expectations, but we're trying to do so now. What you see in Charlottesville and what you see in Richmond and what you see in the insurrection is no. This is the Second Amendment is what we are going to zero in on as a way of making sure that doesn't happen. I mentioned Richmond in January 2020 because I think that was really the precursor, right, to the insurrection of this year. That is, when you've got all of these people armed to the teeth, right, showing up to protest, right, explaining that this is their First Amendment right, that strapping these guns to their backs and walking through these streets is expression as opposed to intimidation or terror. And you have media reporting on this event as a peaceful event. A peaceful event that meant that basically every planned other demonstration, counter demonstration, celebrations, normal course of business of those days were canceled because people did not want to get shot. The city basically has to shut down. There are legislators who are hiding because they have been threatened. And the Democratic bodies couldn't actually do their work. And that's all because of what? Because this group of people felt that the democratically elected legislature was doing something they didn't like. It's as overt as that. We don't like that these people are taking away our rights. And it doesn't matter that this is a democracy. We're going to show up here and we're going to intimidate. We're going to completely stop the machinery of democracy because we don't like the results. And that got promoted as a peaceful event, that it was not seen as the act of terror that it was, I think directly leads to January of this year, where now if you needed them to say it louder, now they're saying it. We're going to tell you that anything that does not result in the result that we want is illegitimate. It is stealing. It is fraudulent. And we are ready to take up arms against it. We are going to raise an insurrection against that illegitimate government. And what they really do mean is you are replacing us. This is no longer within the hands of white men specifically, and people who support the idea that their interests should be at the center. And this resolution quickly to guns and violence is to say we are justified in doing so. We are responding to tyranny. That is what they believed, and that is what they were going to enact in front of, in fact, they did enact in front of all of our eyes. That it is, as again, I hate sort of in some ways, we're gesturing at that Trump statements to explain this, but when during the first election back in 2016, when he was asked whether or not he was going to accept the results of the election, he said, "I will if I win." And that is the entire ethos of this group of people who says we will respect rules if we win. And the implication is if we don't, it's violence. It's not talk about it. It's not protest. It's not elect someone else. It is we are going to resort to arms and to insurrections. And that is the new normal. And depending on how the fallout of this insurrection plays and how much the court intervenes against this extremist idea, we're really just announcing over and over to this radical group of people, yes, you can do that. That is within your rights to do, and we're not even going to respond that much to it.
Great, thanks.
Just briefly, I think one interesting question is, what will the Supreme Court or the pivotal votes on the Supreme Court do with what we're all saying? Because I think they know this, and Chief Justice Roberts certainly knows this, how explosive the Second Amendment can be, in today's America. And it will be interesting to see. I mean, I don't know, but it's the sort of thing that could lead the Chief Justice, perhaps Justice Alito, perhaps others to moderate their what might be a more expansive view of the Second Amendment. And one other quick point is, people have mentioned that the self-defense as the animating purpose of the Second Amendment right, recognized in Heller, certainly a primary one. To me, one very potentially promising argument that we can make on the gun violence prevention side is one that Daryl's colleague, Professor Joseph Blocher, wrote. I may be mangling the title, but his article was something like "The Right Not to Be Armed," and I may be mangling the premise as well, but as I recall, it was making something of the point that if the Second Amendment protects a right of self-defense, to have guns in the home for self-defense, well, most Americans choose to protect their families and their homes by keeping guns out of their homes. And so the Second Amendment, therefore, should protect a right not to be armed. And if you expand that out, it could have some interesting implications. I mean, the domestic violence, the woman who's being subjected to domestic violence by her armed husband, what is her right to engage in self-defense, which is best executed by having her abusive husband not have a gun in the home. And if you take a Second Amendment into the public arena, our best protection, Trayvon Martin's best protection was keeping guns out of George Zimmerman's hands. And so I think there's more to be done with that brilliant piece by Professor Blocher. I do not know how receptive the Supreme Court will be to it, but I think there are sequels to be written on that piece.
I think it's worthwhile just to imagine just how frightening, the January 6th insurrection would have been if indeed there was no regulation on public arms as there are in some states. If people had just decided, I'm not only going to show up, but I am going to storm the Capitol building, as an armed assembly. I think it could have been, it was unnerving and tragic already, but to have the spectacle of the political leadership, assassinated on television would have been incredibly jarring. And I cannot help but think that maybe the Supreme Court, has the January 6th events run through their minds, with arms as they're sort of considering these questions about public arms and whatever regulations are permitted on that.
Great, thanks. And Professor Cornell, I believe you'll have a point to jump in from a historical lens.
So to tie together some of the things that have been said, when I look at the assault on the Capitol, in a way, it provides a kind of dramatization of what we've seen in Heller, which is this almost creative anachronism. The idea that if you put on your polyester tricorner hat and your, permanent press breeches, you're somehow expressing your fidelity to our constitutional past and to the founders. And of course, that kind of living anachronism is exactly what Heller gave us, because Heller didn't take into account, as Jonathan, as John mentioned earlier, that this was a rural, pre-industrial society, a face-to-face society. There were all kinds of ways in which people kept an eye on one another, both for good and for bad. The idea that you could walk into a Walmart and buy a gun anonymously just would not have been conceivable. I mean, we didn't have the productive capacity. The market wasn't structured that way. So the idea that we're abstracting a kind of liberty principle and ignoring the way that guns were embedded in a very real social context at the time, and that social context was all about a part of the Second Amendment that does not get much mention, which is the security of a free state, and that guns without regulation is not liberty. It's what the 18th century would have called licentiousness. And that's a term that is completely dropped out of our political vocabulary. But, you know, modern law starts with this idea that liberty is the inverse of power and that regulation is antithetical to liberty. But the most fundamental belief that runs throughout the entire founding period is that regulation is the absolutely essential foundation for liberty, and that without regulation, there is no liberty. What you have is anarchy. And the key is, how do we operationalize that, both in terms of popular understanding of liberty? It's very easy to articulate a kind of modern libertarianism. It's very difficult to explain to people this 18th century concept of ordered liberty or well-regulated liberty. And how do we make sure that the courts, ultimately the Supreme Court, understand that side of the history, that there is in fact, you know, when Justice Scalia talks about the problem of freestanding balancing, whatever that actually means, you know, Joe Blocher has this great article in the Harvard Law Review where he points out that that concept has nothing to do, you can't find any foundation for it in the founding era. There's no founding era text that Justice Scalia cites for that. It turns out it's Hugo Black's view of the First Amendment, that that Justice Scalia is not grounding his critique of balancing in founding era ideas of rights. He's grounding it in a very modern First Amendment doctrine that has no relationship to the founding period. So, I mean, I think that's part of the problem when we try to untangle these threads in Heller, is that it's what Reva Siegel calls temporal oddities. That, you know, one moment you're in the 18th century and then it's back to the future. You're sitting, you know, in the Supreme Court with Hugo Black pushing back against Felix Frankfurter. And I don't think Heller has gotten enough attention in terms of the way that it's just incoherent in large parts of the argument. I mean, it just is almost crazy at some points, where the way the text, you know, weaves back and forth in time.
Great, thanks. And I think just a message to those watching on Facebook Live, we will be leaving time at the end to take questions. So if you post a question in the Facebook comment section, we will be able to see those and pass those along to our presenters. So I think I'll direct this next one to Hannah and John, building off what Professor Cornell said. You know, gun violence seems to offer a vivid illustration of the chasm between thinking about the Constitution intellectually and what that means when people are actually dying, you know, by the tens of thousands, or 100,000 people are shot every year, about 300,000 die. Given that, what do we do with Heller going forward? As Professor Miller has said, it's unlikely that it's going to be overturned. So, like, what do we do now, knowing, you know, the foundations are shaky, but we still have to work with it, and we have real policies that we'd like to get implemented?
I can start. I mean, I'm a little, you know, I think that the future is a little murky on this point. I mean, I think Heller is one thing, but it now looks like we are poised to see a decision from the Supreme Court that pushes the Second Amendment in a more absolute, unbounded direction, even than Heller. And in some ways, you know, maybe casts aside some of the limits that Heller adopted, like its acknowledgement that a number of gun safety regulations don't raise a constitutional question. You know, the kind of decision I'm worried about is one that really constitutionalizes every question and leads to another wave of lawsuits, just trying to make every single thing into a Second Amendment issue, leaving, you know, nothing outside the scope of the Second Amendment. And I think, you know, the response to Heller is, I think Heller leaves room to adopt gun safety regulations, and the next step will, you know, when there's another decision is going to be to engage with it like that. You know, what is still possible after the Supreme Court further pushes the boundaries of the Second Amendment. You know, I think that there's going to be some policies. I hope there's going to be some policies that are safe, like a universal background checks law. Like, to me, that has to be consistent with the Second Amendment. But there's going to be a number of other policies that are going to be in jeopardy, and I think we're going to see new, you know, fresh lawsuits filed to issues that have been resolved over the past 12, 13 years since Heller was decided, and it really might be off to the races again with you know, territory left undecided by the Supreme Court that's going to get litigated over and over again. So I don't know if that answered your question, but I think there's, you know, when I think about what's coming around the corner, it's going to be a lot of work similar to what happened after Heller was decided.
I mean, I certainly agree with Hannah about how dire things could be, and the tremendous stakes of the Supreme Court's next Second Amendment decisions. I'm keeping some room for optimism, because I think that's the only thing we can do, and I do think there is a chance that the Chief Justice can, and you know, obviously colleagues can come together with some interpretation that allows for, you know, public safety regulations in some ways. We'll just have to see what the case is, but I you know, as Daryl said, I have to believe that the Chief Justice and others know what January 6th could have been like if, you know, the extreme view of the Second Amendment were the law of the land. You know, of course, DC would not have its gun laws then. So, you know, I have some hope, but we'll have to see. And the stakes, you know, are extremely high, and we've never dealt with anything like this in American history. You know, there's, you know, Heller was historic, but it was the result was somewhat modest. You know, it took bans on guns in the home off the table, but there were very few of those in the country. And, you know, Brady, for example, did not support them as a matter of policy. We thought they were constitutional, but as a matter of policy, it was not part of our agenda. So, you know, the stakes are huge here. So we'll just have to, you know, we'll have to see. And I also think, to Professor Cornell's point, you know, Heller as a opinion has been criticized so harshly across the political spectrum. You know, some conservatives, Nelson Lund, who agreed with the general ruling, but was very sharply critical of the opinion, and Judge Posner and many others, that I wonder if some justices are going to think that they should not build this sort of skyscraper on the foundation of this extremely shaky ruling that Heller was.
Yeah, and if, you know, the court will have the opportunity to expand Heller and the right recognized beyond, you know, a right to own a gun in the home to a right that extends outside the home, which might implicate laws that generally enjoy broader public support, like requiring a permit to carry a firearm in public, and things like that. So I'm curious to hear, based on the ability of maybe a court that's out of step with public opinion on, what are reasonable gun laws, if applying Heller and expanding Heller, what is your reaction to the discussions around potentially expanding the Supreme Court, and what do you think that might mean for the Second Amendment? No one wants to go on the record with this one.
I don't.
Happy to skip over it. We've got some good
Yeah,
questions.
I don't have an answer to that. I think I do wanted a couple of responses to what John and Hannah said. I mean, I might be an outlier in this, but I think one of the issues is, as everybody sort of understands, the vast majority of Americans don't see or understand these things as in sort of ineluctable tension. They understand that there's a right to keep and bear arms, and they understand that there's reasonable regulation of the right, and in terms of popular polling on a whole suite of different kinds of gun safety legislation of various kinds enjoys incredible support, even by gun owners. So, what we're talking about is the Supreme Court sort of engaging in a very thin slice of what I think would be popular opinion on the gun rights side if it was to really start jettisoning, the whole host of gun regulations that exists. To Hannah's point about the Constitution, I don't think. I mean, the next case I think will be big. It'll be important, but where all the action and all the what I would say is problems or mischief that is happening is at the state and local level. So it's not that, Heller, for example, says itself, you can have and prohibit concealed carry. So the fact that states enact laws that say we'll let permitless carry, you don't even have to have training on where to point the gun. We'll just let you carry that. That's all. That's not, the Second Amendment doesn't require that. That's happening at the state and local level. And this goes back to the point that I was making at the beginning, which is, to the extent that you have those kinds of rights that aren't required by the Second Amendment, in fact, are firmly said are not part of the Second Amendment in the Heller opinion, articulated as if they were Second Amendment rights, then that's the real issue about how the politics of the Second Amendment have been outstripping the law. And the more we see extremely expansive gun right legislation at the state level, the more it's going to run into other kinds of values. Again, I can't say this enough, which is, the Supreme Court is going to have to square things like, can you carry a gun, into a polling booth? Can you summon, poll watchers armed at the polling station, right? This is not a theoretical thing. I think we are 1 to 2 election cycles away from, people sort of declaring themselves as poll security agents and then just showing up, at polling sites with arms. And that's something that the Supreme Court is just going to have to deal with someday.
Great. And we've got some questions from online attendees, so I'll post this first one. What does the panel consider to be the strongest arguments that can be made in an amicus in cases expected to come before the Supreme Court to persuade that history, text, and tradition of the Second Amendment should not be viewed in isolation? And what two-step analysis adopted by most circuit courts of the appeal should be adopted? I think if I direct that one at Hannah, will that be the best way to start?
Well, I was going to say that I believe Daryl did an amicus brief, the last Supreme Court case, on the two-step test and why that should be adopted. So I think that Second Amendment law professors could be a persuasive voice for the court. But yeah, it's a good question. I don't know. I mean, I feel pretty pessimistic about the two-part test, which is strange because this is what all of the federal courts of appeals apply as the test. And the court has denied cert for many years in cases seeking to jettison the two-part test in favor of text, history, and tradition. And yet, just given the clues that we're getting from the court, it seems to me like it's on its way out. So I don't know. I mean, I think it's a great question to think about, what could persuade them to keep it. I think doing maybe comparison, comparing to other constitutional rights and showing the justices that this is really normal constitutional law, nothing to see here. There's also professors who have done empirical work trying to show that the two-part test doesn't result in gun laws just always being upheld, that it's a exacting analysis of their constitutionality. But if I had like the best idea, I'd maybe have a better answer to this question, but it's worth thinking about for the next time a case goes up to the Supreme Court.
And I just add to that, and I'm not just playing to the audience, but Professor Cornell and other historians have filed very impactful briefs, and in both Heller and McDonald and other cases, and that's obviously a central area. The court purports to look to history, and Professor Cornell explains that the history supports gun regulation and upholding it, and it's very hard to refute that.
And that's a reason for optimism, just to follow up that even if the two-part test goes away, there's still a lot of work to be done with a historical approach to the Second Amendment.
Yeah, and I think this next question definitely builds on that response, but I'll open it up more broadly. So what arguments do you think are most likely to sway the new justices on the court to uphold gun regulation? Or what types of original arguments specifically?
So I think this is aligned with the remarks before, which is, first of all, that there's actually lots of gun regulation. I mean, gun regulation just doesn't drop from the sky after the assassination of Kennedy and MLK in the 60s. There's a long history. The question is, like, again, what level of generality? And this is, I think I'll piggyback on what Hannah and John said, which is, almost, if I was a gun rights advocate, I think I would want to preserve the two-part test. And the reason why is this. I can't imagine a Supreme Court of the United States saying you can carry armed guns onto airplanes. And if the only thing they have in their toolkit is text, history, and tradition, then the level of generality about the regulation has to be extremely broad. And then, that, airplanes are congested places, or, places where there's a lot of danger or whatever, see a bunch of history. And then that would anchor the next case about, well, this isn't a plane, but this is a place where people are in tight spaces, and therefore we can imagine that's why you would be able to prohibit guns from there as well. With the two-part test, at least the government has to show some empirics or something like that. So I actually kind of wonder whether, as is widely known, when the gods want to punish you, they give you what you ask for. I kind of wonder if they, if gun rights advocates got a pure text, history, and tradition approach, would they really be happy necessarily with the outcome? Because I can't imagine a scenario in which the Supreme Court says, yeah, you can go ahead and carry guns onto jet airplanes, loaded guns.
Great. Well, I think, so we're just about at time. I want to thank everybody for your time. This has been a really fantastic panel and a really interesting discussion. Thanks to all the attendees for joining us as well. We really appreciate your interest in the subject. So thanks again to all of you. Really appreciate it, and enjoy the rest of your week.
Thank you.
Thank you.